Come to order. Without objection, the chair is authorized to declare recess at any time. We welcome everyone to today's hearing on clemency and the Department of Justice. I will recognize myself now for an opening statement, and I thank our witnesses for joining us today. We've got a great panel of witnesses across the spectrum, and so I'm grateful for you being here. The business before us is a hearing titled The Examination of Clemency at the Department of Justice. This hearing examines, among other things, the Department of Justice's unprecedented re-prosecution of someone whose prison sentence was originally commuted by President Donald Trump. This unprecedented prosecution is just the latest in a pattern of repeated systemic corruption by this administration's Department of Justice. Why? Because this individual had received his pardon, actually commutation by President Trump. Former white supremacist in chief, as one of my colleagues on the Judiciary Committee said just yesterday when defending the lies of our now censured Democrat colleague, but they loathe the former president, loathe his official actions, they loathe his treaties and his policies and his supporters. It's no longer a question. There's an old football saying attributed to legendary coach John Madden: if you've got two quarterbacks, you have none. And our two-tiered justice system is such that, in my mind, we don't have justice. Because if somebody's being treated differently than someone else, then you just simply don't have justice. Lady Justice is supposed to be blindfolded. The Department of Justice has the responsibility of ensuring the equal application of law and justice for all. And yet it has failed us. It has failed you, the American people, who depend on these standards every day. Under the leadership of Merrick Garland, the Attorney General, the Department of Justice has weaponized its power in unprecedented ways, with new examples seemingly uncovered every week. In recent times, we've seen President Trump indicted for conduct also committed by Secretary of State Hillary Clinton and Senator Joe Biden. We've heard reports that prosecutors have quotas for the number of January 6 related cases they must bring. We've seen Catholic worshipers targeted in churches and concerned parents targeted by this DOJ at school board meetings. And just yesterday, Special Counsel John Durham testified about his report that found systemic problems within DOJ and FBI, which were weaponized by individuals with political bias against President Trump. In his report, Durham called the treatment of Democrat Clinton and Republican Trump, quote, markedly different, close quote, from each other. And we saw Hunter Biden escape meaningful judgment for crimes he admitted, and just this morning, the Ways and Means Chairman, Jason Smith, released a report detailing disparate treatment. I thought prosecuting an individual who breaks the law, especially the crime as serious as possessing of a firearm, was something we could all agree on, but apparently not. So just this morning, as we look down again at the Ways and Means Committees, they brought forth allegations from whistleblowers that the DOJ, FBI, and IRS were told to stand down on Hunter Biden's investigations. These whistleblowers were stonewalled and retaliated against after recommending prosecution for what they believed were crimes supported by thousands of pages of evidence. And we do care about justice, about law and order, and about standards and accountability, and we need to get it. Americans are tired of multiple standards. And just yesterday, our friend Mr. Liu from California reminded us that the House Judiciary Committee is responsible for helping to ensure the rule of law. And that brings us to the case of Mr. Esformas. In 2016, Philip Informus was convicted on 20 criminal counts related to healthcare fraud, money laundering, and bribery, 20 counts. But on 6 counts, the jury failed to reach a verdict. Yet the sentencing judge, in his sentencing statement, factored these hung jury counts into the sentence. The prosecutors in the case also committed gross prosecutorial misconduct by receiving materials protected by Esformas' attorney-client privilege. That was the way it was found by the judge, yet they were allowed to remain on the case. To resolve the injustice, President Trump commuted Esformas' prison sentence in 2020. However, only a few months later, Biden's DOJ announced that it would seek to re-prosecute Esformas on the hung counts. The Biden DOJ's re-prosecution of Esformas is objectively political, and it's unprecedented. This isn't justice. This is injustice. It's a very unprecedented and chilling decision. Anyone who ever received a grant of clemency from any president should be extremely concerned. Presidents grant clemency to avoid injustice for exceptional cases, and Mr. Esformas' case is exceptional. Now President Biden thinks he knows better than Trump. but he doesn't. And he is setting a dangerous precedent that any administration going forward can re-prosecute those granted any form of clemency by past administrations. Where does it end with this DOJ and with this administration? It is painfully clear that we are dealing in a two-tiered, or in my opinion, a system of injustice rather than justice. I again thank our witnesses for coming here today. I look forward to hearing you on how we can hold this DOJ accountable and identify legislative solutions to move us closer to the promise of equal justice for all. Thank you, and I yield back. And I now recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. First of all, let me say I have no idea what the Durham committee has to do with the subject of this hearing, but never mind that. Mr. Chairman, Republicans have called this hearing to call attention to the case of Philip S. Formas, who was convicted on 20 charges flowing from the largest healthcare fraud scheme ever investigated by the Department of Justice. Under this scheme, sick elderly patients were moved from one facility to another to maximize billable services. Some patients received unnecessary treatments, while others testified that they faced poor conditions that were easier to cover up, as Mr. Informas bribed a state nursing home regulator. After a weeks-long trial, a jury found Mr. Informas guilty of 20 counts and deadlocked on 6 counts. He was sentenced to 20 years in prison, required to pay $5.5 million in restitution, and forced to forfeit $38.7 million obtained from the scheme, until he got the attention of President Trump. In the final months of the Trump administration, Mr. Informas' legal team used their connections to reach out to the highest levels of the White House. And on December 22nd, 2020, with days left in his presidency, Trump commuted Mr. Informas' sentence. Notably, the commutation left in place the restitution, the forfeiture judgment, and 3 years of supervised release. And the commutation did not affect the 6 counts for which the jury deadlocked, counts that Trump could have pardoned but didn't, leaving the door open for prosecutors to retry Mr. Informas, as they are now seeking to do. Republicans say that this case illustrates that we have a two-tiered system of justice. Far too often that is right, but the tiers are not based on political views. While Republicans imagine that white, wealthy, conservative men are the victims of these disparities, Democrats know that it is actually poor people and people of color who find the deck stacked against them. Whether you spend the night in jail doesn't turn on who you voted for, but it might very well turn on whether you have a lawyer on speed dial or enough money to post bail. Clemency should act as a corrective to a justice system that is not always just. In Federalist 74, Hamilton described presidential pardons as, quote, as an act of mercy, close quote, that balances a justice system that might otherwise be too cruel. But it can just as easily perpetuate injustice, becoming yet another way to divide those who can afford to access it and those who can't. In the vast majority of cases, President Trump bypassed the clemency procedures followed by his predecessors, both Republican and Democrat, bypassing the pardon attorney whose function it is to examine the 20,000 or so pardon applications received each year, and creating a situation that favored his political friends, the well-connected, and those with the money to buy their way out. So it is not surprising that someone like Mr. Informas was able to reach the president's desk. But for every case like his, there are hundreds, if not thousands, more people in our federal prisons who cannot afford a whole team of lawyers to pursue clemency and who are not able to persuade a member of Congress to hold a hearing on their case. Last Congress, Democrats held a hearing about those individuals, and they still need our attention. We heard from Mr. Osler and others about ways in which the clemency process can be improved, and I look forward to discussing that again today. Last Congress, we also addressed the problem of enhanced sentences for acquitted conduct, which parallels the legal problem presented by the counts on which the jury was hung in Mr. Informas' case, but for which his sentence was enhanced. We passed the Bipartisan Prohibiting Punishment of Acquitted Conduct Act, sponsored by Congressman Cohen, which would ensure that prison sentences reflect only the crimes for which a person is convicted beyond a reasonable doubt, as the Constitution requires. Unfortunately, this bill was never taken up by the Senate, but we can and should work together again to address this injustice in a bipartisan fashion. The majority has called this hearing to talk about a case that Trump could have ended, a case that is still working its way through the courts, and a case that has no congressional remedy. Instead of focusing on one case, We should discuss what we can do to improve sentencing, clemency, and other aspects of our justice system for the many thousands of others who do not have the money and connections that Mr. Isformis has. I hope our experts will help us explore these important subjects and shed light on how we can work together on meaningful reforms. I yield back.
Gentleman yields back. I now recognize the ranking member, Ms. Jackson-Lee, for an opening statement.
Thank you, Mr. Chairman, for your courtesies. Thank you to the ranking member and other members who are here on the subcommittee on crime and federal government surveillance and this hearing of examination of clemency at the Department of Justice. Today we're here to discuss the commutation of Philip Isformis, an individual who, according to a press statement released by the Department of Justice under the former president, led to one of the largest healthcare fraud schemes in history. The case was investigated by the FBI and HHS, Office of Inspector General. It was brought as part of the Medicare Fraud Strike Force by the U.S. Attorney's Office for the Southern District of Florida, with assistance from the Florida Attorney General's Office Medicaid Fraud Control Unit. One agent in the FBI's Miami field office once described him as a man driven by almost unbounded greed. For nearly 2 decades, Mr. Isformis bankrolled his lavish lifestyle with taxpayer dollars, paying bribes to doctors, regulators, and inspectors, and stealing Medicare and Medicaid funds by billing for services that people either did not need or did not receive. These fraudulent healthcare claims, which robbed American taxpayers of more than $1 billion, were finally uncovered after a lengthy investigation and led to a 35-count indictment that named him and his 2 co-conspirators. After a jury found him guilty of 20 counts of bribery, illegal kickbacks, obstruction, and money laundering, he was sentenced to 240 months imprisonment, ordered to pay $5.5 million, and a forfeiture of nearly $40 million was entered. However, just over a year later, he received a commutation which freed him from prison immediately, but left the other aspects of his sentence intact, including a 3-year term of supervised release. Unfortunately, for him, no one thought about the 6 outstanding counts that the jury was unable to reach a verdict on. Apparently, the prosecutors in the Southern District of Florida do not believe that justice was served, and they have made it clear that he will be retried on the outstanding counts. So today, the majority is holding a hearing purportedly about clemency, but just last Congress, we convened a hearing to discuss the backlog of thousands of clemency petitions, mostly for commutations, languishing somewhere in the clemency process, representing thousands of people in the federal prisons across the country, waiting often with false hope to hear something from the Office of Pardon Attorney. I will take just a moment to say, that is the crux of our problem. Thousands of backlog cases, people who are credible and qualified, meet the eligibility standards, and there they are languishing. Just a few minutes, I was on the phone with those who advocate for people trying to fairly access this process. You can't have a process and then have it ignored as it relates to those thousands that are in line, those thousands of families. This is a different question. So during that hearing, the Republicans expressed skepticism about the need to reform the clemency process or for the president to utilize his power of clemency more frequently. It looks like we need that. I recall that Republican witness Mr. Mike Hurst, the former U.S. Attorney for the Southern District of Mississippi, under the previous administration, said during the hearing that asking the prosecutor's opinion of a petition is not only appropriate, but it is vitally important, as no one knows these defendants and the circumstances surrounding their cases better than the prosecutor. That did not happen in this gentleman's case. There were at least 10 attorneys from the U.S. Attorney's Office who worked on the case, from the fraud section chief, assistant chief, to the trial attorneys, to the forfeiture division, not to mention the countless number of agents and investigators who scoured mountains of medical and financial records for innumerable hours. From what we know of this case, not one of them was consulted about his commutation. For the last several days, we have heard about a 2-tier system of justice from Republicans. This hearing and his case are indeed evidence of an unbalanced system of justice, one that exists only for the wealthy and well-connected. The 2-tier system of justice has operated for centuries in America, in small towns and big cities, in Congress, and in the White House, and it's not drawn along party lines. I and my Democratic counterparts in Congress and those who came before me have decried a two-tiered system of justice since the founding of this country. Just days after we commemorate the day in which enslaved people finally found out that they had been freed 2 years prior, we are here to discuss the so-called miscarriage of justice suffered by an individual whose access delivered him from a prison cell within just over a month. Again, while thousands languish, Dr. Kirby John Caldwell, Reverend, languishing, having paid off all of the people that he offended, as alleged. I'm aware of the criticism of the clemency process as it exists today. As we discussed during our hearing last Congress, the process is flawed and cumbersome and in need of reform. I expect that some of our witnesses today might suggest that it was those well-known issues with the clemency process that led the former president to sidestep the pardon attorney and other DOJ components to rely on an ad hoc system developed by Mr. Kushner and others and predicated on access. This ad hoc system was a gift and a curse. I believe it was Mr. Tiffany who during the last hearing on clemency posed this question of Rachel Barkow, who proposed the creation of a clemency advisory board. Are we setting up a parallel bureaucracy that ends up just being a problem? In the case of this gentleman, the answer is yes. He could have been shielded from any further prosecution by a pardon. Unfortunately, he was not. He received a commutation, which we all know, by definition, only reduces a sentence and does not impact a conviction. He is now facing retrial because there are those who believe the commutation sends the wrong message about the seriousness of healthcare fraud and undermines our system of justice. That is a prerogative of the prosecution. Whether or not the actions taken by the Southern District of Florida set a bad precedent remains to be seen. I'm sure that practitioners will take a note and ready themselves for such circumstances in preparing their clemency petitions in the future. It is my hope today, Mr. Chairman, that our discussion extends beyond the commutation of this gentleman to the consideration of the outstanding counts for which he was not convicted to justify the 240-month sentence. Last Congress, we passed a prohibiting punishment of acquitted conduct sponsored by Ranking Member Cohen with an overwhelming bipartisan vote. Let us do so again and make sure that it reaches the President's desk this time. No person should be subject to punishment, especially prison, for conduct which they have not been convicted either by a jury or a knowing plea of guilty. And if Republicans really want to address disparate treatment, I'm here for you. In a two-tiered system of justice, they will join us in getting the Equal Act to the President's desk. Let us finally eliminate the crack to powder cocaine sentencing disparity that has been responsible for decades of unnecessarily long prison sentences for all people, including Black and brown people. And let us work together on a gun storage bill that should have bipartisan support. I look forward to a robust discussion with our witnesses. Thank you for your indulgence, Mr. Chairman, and I yield back.
Thank you, Ms. Jackson-Lee. I just want to make one correction or clarification. Mr. Esformas actually spent 4.5 years in prison.
Okay, thank you so very much.
Yeah, thank you.
Maybe I missed that in my statement. Thank you.
Thank you. And now I'm going to introduce our witnesses. But before we do that, I think I want to ask you all to stand up so we can administer the oath of office. So if you each stand up, please. Not the oath of office, but the swearing in. Yeah. Okay, here we go. If you'd each raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect the witnesses have answered in the affirmative. You may be seated. Our witnesses are Professor Berman, Douglas Berman, who is the Newton D. Baker and Hostetler Chair in Law and Executive Director of the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. His principal teaching and research focuses in the area of criminal law and criminal sentencing. Thank you, Professor Berman. We have Professor Mark Osler, who has been here before this committee before. I think maybe last year on the bill we were talking about. Professor Osler is the Robert and Marion Short Distinguished Chair in Law at the University of St. Thomas School of Law. His work focuses on criminal law and procedure, the death penalty, federal commutations, clemency, and prisoner rights. Thank you for joining us, Professor. We also have Mr. Brett Tolman. Mr. Tolman is the Executive Director of Right on Crime and a founder of the Tolman Group. Right on Crime supports conservative solutions for reducing crime, restoring victims, reforming offenders, and lowering taxpayer costs. Mr. Tolman is a former U.S. Attorney for the District of Utah, and we appreciate all of you being here today. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. And with that, we're going to begin with you, Professor Berman, please.
Thank you very much. Thank you for this invitation to appear. I have spent decades studying the federal sentencing system as a law professor at The Ohio State University and as an editor of the Federal Sentencing Reporter. My research has led me to long advocate for more robust and more regular use of clemency authority. Clemency, of course, has a rich and distinguished history. The framers of our Constitution robustly championed executive clemency power. Alexander Hamilton, mentioned earlier, stressed the importance of clemency in the Federalist Papers, and yet given that the framers fought a revolution to break free from British monarchy, it might seem curious that in Article 2, Section 2 of the Constitution, they granted the president such broad, maybe even king-like power to grant reprieves and pardons. But in a recent article, Professor Osler, here with us today, explained so well why it's not that curious why the framers framed the clemency power this way. As he put it so well in his article, the fear in creating presidential powers was tyranny, but clemency is uniquely ill-suited to the purposes of a tyrant. After all, tyrants are enabled by imprisoning those who they hate, not by letting people out of prison. Another way to say that is that clemency fundamentally serves as a check on the government's awesome power to punish. But in turn, that means that efforts to limit or undermine clemency authority only works one way, that is to pose real risks to individual liberty. This is why Alexander Hamilton in the Federalist Papers described the benign prerogative of pardoning and stressed that humanity and good policy conspire to dictate that this power should be as little as possible fettered or embarrassed. What the framers fully understood is not just that clemency is a benign power, but that efforts to limit it or undermine clemency authority can be malignant to those who care about human liberty. Those realities account for why I find so deeply troubling any Justice Department efforts to re-prosecute any clemency recipient for conduct related to a clemency grant. Besides the particulars of any one case, the transcendent structural and constitutional principles at issue here make the particulars of one case actually somewhat beside the point. There's always going to be some government official who thinks to themselves, convince themselves, maybe even convinces others that some clemency grant wasn't truly deserved or was in some way unjustified. That's always going to be an argument that those who prosecuted think is convincing. But our Constitution's text, history, and tradition makes plain that once a president decides to be merciful through an official clemency grant, that is the end of the matter. Of course, what ends up being endless are the harmful consequences that can flow from any precedent that there can be a post-clemency re-prosecution. The chill that creates for thousands of individuals who have received pardons and commutations from past presidents. They can no longer feel secure in the repose that clemency is supposed to provide. It's so common for prosecutors in the federal system to pursue multi-count indictments, and oftentimes those counts aren't fully resolved through the plea or trial process, as was true in the Asforma's case. In a world with post-clemency re-prosecutions, any unresolved count becomes a tripwire for clemency recipients, and that can have echoes through the entire justice system. More broadly, of course, the public is sure to lose faith in the clemency process if they learn that the punitive whims of prosecutors can lead to the circumvention of clemency grants through re-prosecutions. There's been mention of acquitted conduct, and I appreciate that coming up because it seems to me that's another example of where we see prosecutorial zeal overcoming our constitutional checks and balances. I surmise it's the same kind of tunnel vision that sometimes prosecutors get where they ignore whether it's a jury acquittal or a presidential commutation to want to add punishment anew. To me, that's just so worrisome in both kinds of cases. I so respect the work of the subcommittee and the committee to move forward the acquitted conduct, Prohibiting Punishment of Acquitted Conduct Act. I suggest moving that forward again. I also highly recommend, it was already discussed, but I'd love to discuss more in the Q&A, creating a clemency process, perhaps with a separate clemency board or other independent of the Justice Department unit that assists the president, creates a regularized process so that there can be consistency and robust use of the clemency power that not only is critically important for individuals seeking clemency, but for our broader understanding of the importance of this power as a way to check and balance the government's awesome powers to punish. Thank you so much, and happy to answer questions.
Thank you, Professor. And now we're going to turn to you, Professor Osler, for your 5 minutes.
Thank you, Mr. Chair, members of the committee. It's a pleasure to be back before you, and it's an honor to serve with the two experts on either side of me as well. I'm a law professor in Minneapolis at the University of St. Thomas. I'm a former federal prosecutor, and later this summer, I'm going to be taking a leave of absence to serve as the deputy county attorney in Hennepin County, Minnesota, and the head of the criminal division. For the past 14 years, I've studied clemency. Initially, I was spurred in that direction by Doug Berman. In fact, I've personally drafted dozens of pro bono clemency petitions and supervised hundreds more. I'm profoundly discouraged by the state of federal clemency and the role played by the Department of Justice and the White House in that process. Currently, there are nearly 17,000 petitions pending, and little hope for those who have submitted those petitions, many of whom I know and have worked with. My understanding is that the members of this subcommittee would like to discuss the case of Philip Formis, which raises important questions. And I hope to do so in the context of the broken clemency evaluation system, which failed both him and those thousands of people who wait with dimming hope for a decision on their own petitions. The Department of Justice may prove to be brutally efficient in recharging Philip Formis on the hung counts in his verdict. Meanwhile, they are, with the White House, brutally inefficient in providing thorough and consistent advice to the president on clemency petitions. In my written testimony, I've included a chart which shows the current evaluation process, which has at least 7 levels of review, one after the other. One way to think about it is as a water flowing through a pipe, and there's 7 valves in that pipe, each one of them spring-loaded shut, and they have to painstakingly be opened for the water to flow through and for a petition to be granted. The first step is the pardon attorney staff that evaluates the case, and as was mentioned previously, they're going to get the opinion of the U.S. attorney who prosecuted the case. That person will make a recommendation to the pardon attorney. Then it goes to a staff member for the deputy attorney general, who makes a recommendation to the deputy attorney general. This all within the Department of Justice, 4 separate levels of subsequent reviews. Then it goes to the White House, and there it goes to the White House counsel's staff, and then to the White House counsel, and then maybe, sometimes, rarely, never, to the president. This doesn't work. Of course it doesn't work. Those of you that have a background in business know no business would make decisions this way. So presidents get to the end of the term, and they've gotten no good recommendations, or very few. And they decide to act outside of the system, largely. And that's what was happening in December, on December 22nd, in 2020, when this grant was made to Philip Formis. That at that time, President Trump had made 16 commutation grants up to that point in the first nearly 4 years of his term. And in that last month, he made 78. So there's a mad rush at the end that makes proper advisement impossible. And so this warrant, the pardon warrant, was silent as to the hung counts. And that's just bad drafting. President Trump could have simply pardoned the hung counts or made it clear that he wasn't doing so, but that didn't happen. And that didn't happen because this system doesn't work. It failed Philip Formis, it failed justice, and it's failing the 17,000 people who are waiting and who call me and write to me wondering what's going on with their petitions. As a person of faith, I'm outraged that mercy, a value embedded in my faith and in the faith of many others, and in the Constitution, is given no respect by this system. If you're a business person, you should be outraged that a process is being used that no good business would adopt to decide human fates. If you're a progressive, you should be outraged at a system that systemically and disproportionately harms the people who have the least is denied this safety valve. If you're a libertarian, you should be outraged that this tool to literally grant liberty when it's been earned and deserved is stifled. But if your goal here is just to protect the institutional power of the DOJ, you probably like things the way they are. Thank you.
Thank you, Professor. Now, Mr. Tolman, you're recognized for your 5 minutes.
Chairman Biggs, Ranking Member Jackson Lee, and members of the committee, thank you for the opportunity to testify before you today. As a former federal prosecutor and former U.S. attorney and now executive director of Right on Crime, I am concerned about DOJ, including their vision of clemency. Thomas Jefferson wrote, "The most sacred of the duties of government is to do equal and impartial justice to all its citizens. Philippus Formis deserves no less." Yet DOJ appears determined to deny Mr. Formis that justice, which is supposed to be the bedrock of the American legal system. DOJ's unflinching decision to retry Mr. Formis on the open counts betrays its prior representations to the court, nullifies a presidential grant of clemency, and what should concern us all is nakedly vindictive. This complete disregard for our core constitutional principles cannot and should not be tolerated. Before we can fully capture the extent of the problems with DOJ's unreasonably dogged pursuit of Mr. Formis, we must first acknowledge how rare and precious executive clemency has become at the federal level. In recent decades, presidents have typically granted some form of clemency to no more than a couple hundred individuals over the course of an entire presidential term. President Biden, for his part, outside of his dramatic but largely empty announcement on marijuana convictions, has granted a mere 120 petitions in his first 2.5 years in office, most of whom were already out of prison. Small in absolute terms, these clemency actions are positively minuscule compared to the volume of petitions for clemency the executive branch receives. As of this month, for example, there are 16,933 pending clemency petitions. One look at the current clemency process, decades in the making and reinforced by President Biden, and it's not difficult to see why clemency has nearly disappeared. In short, our leaders have forgotten Alexander Hamilton's own observation that humanity and good policy conspire to dictate that the benign prerogative of pardoning should be as little as possible fettered or embarrassed, and instead allowed clemency to be controlled in large part by DOJ. The very same DOJ so dismissive of clemency and eager to undercut it in Mr. Formis' case. Individuals seeking clemency must send their petitions first to DOJ, the same government agency responsible for their convictions. It's a system with a strong structural bias against clemency that practically begs of conflict of interest. It is an awesome power and rightfully among the relatively few authorities explicitly enumerated in the Constitution. Unfortunately, the fact of Mr. Formis' saga revealed DOJ has lost sight of its founding mission and is willing to take any steps and push past legal and ethical boundaries to get what it wants. In 2016, Philippus Formis was tried by a jury which found him guilty of 20 counts. The jury did not reach a decision on an additional 6 counts and did not convict him on healthcare fraud conspiracy. At Mr. Formis' 2019 sentencing, even though he was acquitted of 2 counts of healthcare fraud and the jury could not reach a verdict as to the healthcare fraud conspiracy, the judge sentenced Mr. Formis as though he had been convicted. On the 20 counts of conviction as found by the jury, he would have been facing 5 years in prison. At DOJ's insistence, the judge considered the acquitted conduct and the unadjudicated healthcare fraud conspiracy charge and increased Mr. Formis' sentence to 15 years, imposing a 20-year sentence. After DOJ suggested the retrial of 6 unadjudicated counts was an option, the judge said, "I think I announced at the time of sentencing that in imposing the sentence, I considered the healthcare fraud conspiracy conduct and 5 undecided counts. So I don't know what more DOJ is going to get out of the case and the additional counts." Ultimately, on December 22nd, after spending almost 5 years in prison, President Trump commuted his sentence. A few months after the clemency warrant was issued, DOJ announced its decision, despite having committed to not continue to prosecute Mr. Formis in open court, that they would continue to prosecute him on the open counts. The government is intent on retrying Mr. Formis on counts based on conduct that formed the basis of his 20-year sentence, which was commuted. Another fundamental and equally compelling concept of our criminal justice system is the double jeopardy clause of the U.S. Constitution, which provides that no person shall be subject to the same offense or be twice put in jeopardy of life or limb. Any retrial of Mr. Formis appears violative of the presidential commutation and the double jeopardy clause. Recent events, however, clearly show that for the right defendant, the son of the current president, for example, DOJ is willing to allow a person to move on with their lives. The legitimacy of the entire criminal justice system suffers in the face of such disparate treatment, where a second chance appears granted based more on who a person is rather than what they have done. Thank you.
Thank you. We appreciate the opening statements of all of our witnesses today. The chair now recognizes the gentleman from Alabama, Mr. Moore, for 5 minutes of questions.
I want to thank all the witnesses for being here today. We appreciate you participating. It's amazing to me that the American people have any faith left in our criminal justice system at all. The news from earlier this week definitely didn't help. We're here today to talk about clemency in the case of Mr. Informis. Yet it's hard to talk about anything other than the elephant in the room, which I believe is a two-tier justice system. Just yesterday, the Judiciary Committee heard from John Durham, and I think in many ways it confirmed the FBI and the DOJ are corrupt. And they're willing to go on political witch hunts on certain political parties, even if there's no grounds for doing so. We all know about the double jeopardy clause, the Fifth Amendment. So, Mr. Tolman, I want to hear from you on this. Could re-prosecuting someone after they've been granted clemency be viewed as a double jeopardy issue?
Especially in this case, I would say you're going to have arguments that technically it might not apply because the jury didn't reach a verdict, but the jury was impaneled and the trial did occur on those same counts, and the judge clarified that he was sentenced on the counts he was not convicted on.
Thank you for that. Hypothetically speaking, and this is for any of the panelists that would like to answer, if someone were to fail paying $100,000 in taxes and own a firearm when they're a known drug user, would that person serve time in prison?
Having prosecuted hundreds of those cases, I'm not aware of any instance in which a diversion would be granted under DOJ policy, and I reviewed several thousand similar cases and did not see diversion as an available option from DOJ, and each one served on average of 39 months in prison.
If I could speak to that.
Absolutely.
I don't have an answer for your question because I don't have the data, but I think that's a problem too, that we don't have good data about the way pleas are negotiated. They're national. I've heard this discussed. I heard some of Mr. Durham's testimony, and I know people have strong opinions about what's normally done and what's not, and it's all over the place. And that's a problem. That, one of the things that has been mentioned is the Fixed Clemency Act that was brought last year. Section 7 of that act would require a report on U.S. attorney charging and plea practices to be made. And I think it's high time to do that, because when we discuss things like this, it would be great to know what's actually being done in the shadowy world of plea agreements.
Mr. Osler, as I was having hearings throughout the district last year, one of the big concerns of people was a weaponized DOJ, a fear for speaking up and being targeted. Mr. Berman, would you like to try to address the question as well?
Sure, I'm very inclined to agree with Professor Osler that we need much more data, particularly in the tax setting. Is such an example where there's just so many laws that enable prosecutors with completely unregulated discretion. Should I pursue this as a civil matter? Should I pursue it as a criminal matter? And it's entirely appropriate that there are people concerned that that choice will be influenced by factors that shouldn't be relevant to the operation of our justice system. And I think the lack of transparency we have when it comes to prosecutorial discretion across the board really contributes to an understandable and I think sort of highly problematic concern that it's only the wrong factors that are shaping prosecutorial discretion. And then I will say that this is part of the concern I have with DOJ more generally, is they then will defend themselves on in particular cases and say, no, only the right factors were here, but without a record, without all the data that we need to make those judgments, we have to take their word for it when we can't sort of see the work.
And so these are the charges for Hunter Biden, and we all know he got a slap on the wrist. But a while ago when the ranking member was speaking, these were the things that he said the reason Mr. Informis got a pass was he was white, he was wealthy, he was well-connected, and had direct contact to the president's desk. Do you think in some ways Hunter Biden got a pass because of what they're accusing Mr. Informis of having? Anybody willing to answer that?
The only thing I would say is there should be outrage among especially inner city prosecutions that have occurred by DOJ for the similar gun charges, for example. Diversion is not an option, and if you're not Hunter Biden or you have the Biden name or you have money or resources, it goes to the heart of what I think the professors are saying too, is a justice system that is geared towards favoritism and now towards politics more than it is towards justice and fairness.
So true, Mr. Tolman. I'm running out of time, but as we think about blind justice very often in those scales, we see the statue. The terrifying thing for me, for the American people, is when it's laser focused on political opponents. And with that, Mr. Chairman, I'll yield back.
This time has expired. The chair recognizes the gentlelady from Texas, Ms. Jackson Lee.
I thank the chairman, and as I indicated, I really appreciate the chairman for having this hearing. I hope we can find common ground on one conspicuous set of facts, is that the backlog is just unacceptable. And then I'd like to thank Mr. Berman for joining me and my colleague, Mr. Cohen, on that legislation that clearly should be adhered to, of counts untried, and to even include them, in essence, acquitted or other matters. So thank you for that. But also let me, to the gentleman bringing apples and oranges, the case dealing with the family member of the president was by a Trump-appointed U.S. attorney, and so whatever preference or bias could have been imposed, we should ask that Republican-appointed U.S. attorney what his or her reasoning might have been in this instance, him. So why don't we just stay focused on, I think, a very important topic. And I do understand that Mr. Informaz served 4 years, and I thank you, Mr. Chairman. I think the point I was making is that his clemency process took just a month. Mr. Osler, I'd like to proceed with questioning in your direction, because I like the words that you have said, systemically impacting a person that has the least. The system does that, and I think that we should be concerned about that. Let me ask you, Professor, can you walk us through how past administrations have typically reached pardon decisions and what processes are typically followed? And I have a series of questions, so.
Yes, and thank you for that question. It's evolved over time. The current system developed organically. Nobody planned this. It was basically people delegating to those lower down, the Attorney General deciding not to be involved. It has never been thought out. Now, previous administrations used processes where the Attorney General would meet directly with the President. That was usually somebody that the President trusted. They would meet regularly, and you saw that if you look at the clemency statistics, very often the year with the highest number of grants, including for Ronald Reagan, would be the third year or the sixth year or the fifth year.
Let me proceed with some other questioning. And then I want to acknowledge Amy Puva, Weldon Angelo, Jason Pye, Candia Milton, and Jeff Cook McCormick, who I had opportunity to engage with on this topic. I think they too recognize 17,000 backlog of cases. But did the Trump White House follow these typical processes in exercising his clemency powers?
I believe that they did in 25 of the cases that were granted. So about 1/8 of the cases where there was a grant.
So how did the Trump White House deviate from the procedures?
They had an informal process, as I understand it, that sometimes involved people who had submitted a petition and sometimes those who submitted once they decided to press for it, especially in that last period. It's hard to know what process was actually used. I wasn't a part of it, and so that opaqueness is the opposite of the transparency that this kind of constitutional imperative should require.
Well, in essence, we are throwing oatmeal up against the wall to a certain extent, which is not helpful justice, I would take.
Well, I can tell you this. I know a lot of the people who didn't get granted in that period, and it was heartbreaking to watch the list come out and know that people whose petitions had been entered years before, who'd done everything right, who'd followed the rules and had remarkable reformations, weren't in that list.
So when I asked the question, what impact this had on those seeking pardons, it just crushed them. Is that what you're saying? They followed the rules and they didn't see any light at the end of the tunnel?
That's correct. I received a message recently from a woman named Sarah Carlson. We did her pardon petition. She's been out for several years. She works for a faith-based organization called Minnesota Adult and Teen Challenge. She does fantastic work. She's proven that she deserves a pardon. We submitted her petition years ago. She doesn't know why she's not getting a chance, why she isn't getting the fair shake.
So Sarah is her first name?
Yes.
Sarah, and then there's a Ross Albright, and there is a Dr. Hamilton, and then there's a Reverend Kirby John Caldwell, who paid every cent of his alleged unfortunate circumstance, every cent back to everyone. Let me just quickly, is there anything that you think Congress can do about the clemency process? How can we improve it? And with regard to the extensive backlog of clemency petitions, it's an embarrassment to the Constitution. What can Congress do to help these individuals? Can you just combine those two answers?
Yeah, gentlelady's time's expired. You may answer.
Yes, pass the Fixed Clemency Act, focus on that, and push this president to take clemency seriously. Not only has he not granted many individual grants, he hasn't denied any by presidential action either. He's just ignored it.
Mr. Chairman, quickly, enter by unanimous consent the memorandum to the Honorable Donald Trump on November 6, 2020, and the executive grant of clemency signed by Donald J. Trump, President, December 22nd, 2020. That's unanimous consent.
Without objection.
Thank you.
So ordered.
Thank you.
Chair recognizes the gentleman from California, Mr. Kiley.
I yield back to the chair.
Thank you. So I want to ask a couple questions because I don't think either party has really done a great job handling clemency, commutations, and pardons. But and I don't want to turn this into partisan things. But I think of things like Mark Rich. You know, I mean that is probably the poster child. He still owed $48 million in back taxes, but he donated $1 million to the Dems and received a pardon. Chelsea Manning commuted the remainder of Manning's sentence, and some said that it was too dangerous. Chelsea Manning remained a danger. And the one that always blew my mind was when President Clinton granted clemency to the Puerto Rican terrorist called the Faln, F-A-L-N, if you remember that case. So those things really exist out there. But when we look at this, and we talk about the Informis case in particular, as kind of, because we want to see what's going on in a lot of ways. What happens, and I'm going to ask all of you this question, what happens when to the system of the president's authority when there is a retracing, if you will, by DOJ to come out back after somebody that has the, and these are unique facts, but everybody's got unique facts in criminal law. But what happens to the overall perspective of the public and for those who I mean, let's say you were in that group of FALN, you know, and let's say that George W. Bush said, okay, we're going to come after you. So I'm going to start with Mr. Ostergo, Mr. Berman, and Mr. Tolman. That what is the impact when they start looking back, DOJ starts looking back on these clemencies and say, we're going to prosecute?
Yeah, it's damaging to both the process and to the people who hope for clemency. You look at the process was incredibly damaged by the Willie Horton story, if you remember that. Yeah. And, you know, that wasn't even a clemency, that was a furlough, I believe.
That's right.
And you know, when we had, I mean, the Mark Rich grant, when that came out, I was furious. And so were a lot of other people because it undermined the project of justice and mercy at the same time through a lack of humility. And, you know, but for the people that are involved too, the people who have petitioned, yeah, when they hear about someone re-prosecuted, if they do, that would be discouraging. Looking around at the 17,000 people who are waiting and waiting and waiting, that's what's most discouraging.
Thank you, Professor. Professor Berman.
Well, I would add, and thank you for the question, that it's discouraging for people who might think about applying, would-be applicants, if they have reason to be fearful, as I think many would. Boy, if I even manage to get my case in front of the president and get some kind of relief, DOJ might just come back after me. Why should I bother or go through that hassle and process if I'm not going to get that repose? What really worries me, even thinking longer term, is now when plea bargains are being put together, are applicants going to say, I need to have every single possible count against me resolved? If anything's left lingering, boy, I won't even bother to seek clemency because then I might be subject to it. And I doubt that the problem of re-prosecution would end up growing so much because DOJ itself wouldn't want to do that work and have those problems. But I think the way this could reverberate through our entire justice system, it shouldn't be underestimated if it goes beyond just a single case and becomes a precedent where there's a perception every time there's a new president coming into office and a new DOJ that they should take a look back at the old cases to see if anything was not done just quite right.
Thanks, Professor. Mr. Tolman.
Yeah, the system is broken and both sides broke it. There's no question about that. I worked on clemencies for Ross Ulbricht and Jimmy Roseman, for example, both individuals that believed that they would get a clemency, deserving of a clemency for various and different reasons. Like Mr. Esformis, everybody should have that availability to them, but now their questions that they have are, even if I get it, is DOJ coming at me? And that would only be a DOJ that believes they're a fourth branch of the government.
Yeah, to me, it's the Esformis case, when it was brought to my attention, I thought, well, this is kind of prototypical of the real issue that we see here. How is the system where he got clemency? How is the system where DOJ now is looking back? And how do we fix this system? And so you've all provided some kind of guidance on that, and we'll explore that as we go forward. But I appreciate those answers, and I'm going to go now to recognize the gentleman from New York, Mr. Nadler.
Thank you, Mr. Chairman. Mr. Berman, it's my understanding that in most recent administrations, the President took the advice with respect to pardons and clemencies from the administration of the pardon attorney until Mr. Trump took only 1/8 of his pardons from the pardon attorney, and the rest depended on someone who knew him and recommended it to him. Is that the case, and how has President Biden handled it?
That is my understanding of the way things were processed in front of President Trump. And
what about previously?
Previously, there was an inclination to go through the pardon attorney's office, though I share, and I think the other witnesses here agree, that that's been a broken process, that the Department of Justice, try as it might to have a pardon attorney office that isn't conflicted out by the fact that prosecutors are all around. But the reality is that office has not been providing sensible and effective and regular advice to presidents, really since it went inside DOJ. And that's where I think the flaw in the process is there. If I could just have one moment to describe what I've been working on with folks at Ohio State in Ohio. Governor Mike DeWine, when he was elected, he reached out to us, said he wanted to do the process of clemency better, to do pardons better, and that he wasn't getting a good pipeline of applications. And he worked with our university, the Drug Enforcement and Policy Center, also the Akron Law School Clinic, to build a pipeline where he announced criteria ahead of time that he cared about for a pardon. And then we worked on cases, applications come to us, we judge them by the criteria. We have no bias. Law schools are independent, obviously, of the prosecutorial function. And that has been working incredibly well. Among the things that I've learned through this process is it's an incredible amount of work to build the file, to check records, to do everything that's necessary to put a really good file together for an executive official and say, this is a good case.
And
it's so much work. It's inevitable if you don't have a really well-built process.
And you think
this shortcutted.
And you think a similar process could work at the federal level?
I think it's worth looking toward, and I think it's something that this Congress can do in this process. Obviously, it's the presidential prerogative to do pardoning, but I think this Congress can and should be looking toward building that infrastructure, not leaving it to DOJ, not leaving it to back doors.
Thank you. Mr. Osler, Professor Osler, if President Trump wanted to make it so that Mr. Esformis was fully cleared of wrongdoing, could he have done that?
Yes, he could have pardoned the hung counts.
And if Mr. Esformis received a pardon for the conduct connected to the hung charges, would that have ended his criminal case?
If he'd gotten a pardon on the hung counts, yes.
And if President Trump had pardoned Mr. Esformis for the hung charges, would the U.S. Attorney's Office for the Southern District of Florida be able to retry him on the hung charges?
No.
And if President Trump had pardoned Mr. Esformis for the hung charges, would he still be facing possible additional prison time?
No.
And are you aware of any cases like Mr. Esformis' case where a commutation is given but there are unresolved charges left outstanding in the underlying case?
I'm not aware of any, but I haven't done a systemic search.
Isn't it true that once a case is complete, courts typically require resolution of all charges either by retrial or dismissal. And Mr. Former's case was different because his case was still going through the appellate process.
Well, as I understand it, it's still, they can seek cert on the appeal, so it's still in the appellate process.
And my last question is, presidents have broad clemency authority. It's challenging to sift through the many people who seek clemency to find those who are most deserving, obviously, and align with the president's goals in exercising clemency. And we see through this Formas example that petitioners and those evaluating the petitions must be thoughtful and careful as they maneuver through the clemency process. What changes in these processes would you recommend to the executive branch?
Well, just in brief, Rachel Barcohen of NYU and I have proposed for years to have a presidential commission that would directly advise the president. My home state of Minnesota, just this last term, has adopted that system, changing our clemency system.
And how would that commission be appointed?
It would be by presidential appointment. And so, and there are certain balancing that you'd want to have in that of different talents and so forth would be by presidential appointment. And that's how it's conceived of in the Fixed Clemency Act.
Thank you. I yield back.
Thank you. Recognize the gentleman from South Carolina, Mr. Fry.
Thank you, Mr. Chairman, for having this hearing today, and thank you to our witnesses for being here. U.S. President's clemency power obviously comes from Article 2. It states that the president shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. And you look at clemency just broadly, it is there to correct maybe errors of law, errors of fact, changing circumstances. It is a check on government, and it is, certainly used by the executive, used seldomly maybe, or more liberally in some administrations. But the point of it is to really get back to a fair society. People were given clemency after they passed away or while they're alive for crimes that they may have committed. In December of 2020, we've been talking about Mr. Formas' prison sentence, where President Trump commuted it and left intact, obviously, the restitution and the forfeiture orders. But once President Biden takes office, the DOJ announces that they're going to seek to re-prosecute those hung jury charges. I'm really concerned about why we're here today. I mean, you look at this and where presidents have that authority, it is deeply concerning to me that we would, with a change of an administration, now come in and re-prosecute an entire fact pattern where you had a hung jury. They had maybe opportunities to do that and didn't do it. People are very concerned at home about a Justice Department, a law enforcement agency continuing to push things, and it's you versus the government in a lot of ways. Mr. Formas has already spent 4.5 years in prison. He had a restitution order still intact of $5.5 million and a forfeiture order of $38.7 million. But the DOJ feels compelled to re-bring up these charges. I find it difficult to see how this is not two-tiered justice system. Mr. Tolman, I want to turn to you. Do you believe there's any potential political or personal motivations driving the decision to re-prosecute Mr. Formas? And if so, why do you think that is?
I do. I think there are, because on the record, the prosecutors told the judge that they would not charge those hung jury accounts if the conviction was upheld. It was upheld. The word of the DOJ now, when I was a prosecutor, if I made a representation, even if my boss didn't like it, he was going to back me up on what I represented. Here, they have gone back on their word. They're willing to go forward. And to Ranking Member Nadler's point about, could they have fashioned a pardon on the acquitted or the hung jury counts? Yeah, they could have, but if you are not outraged by DOJ doing this now, the next DOJ, they won't worry. They'll go and re-prosecute on the uncharged counts. You're down a slippery slope, granting or accepting or not getting outraged at DOJ doing this because you don't know what power they're capable of if you don't stop them now.
In your opinion, just looking at this holistically, one of the things that I think that has benefited this country for a very long time is our faith in the institutions, our faith in the rule of law. Does this eradicate or erode American citizens' faith in the rule of law, in our system, in our justice system, in your opinion?
It absolutely does. I worked on a pro bono case for a woman named Adrienne Miller, and she was nobody, had no money, and was granted clemency by President Trump. And they need to have that opportunity and know that that's a possibility. In the current system, it's not. And then you're going to add on top of that DOJ will ignore a presidential grant of clemency to go after him. It's offensive to our law and order system and to our Constitution.
Mr. Tolman, in June of this year, you tweeted that if the DOJ treated Hunter Biden like the thousands of no-names who get prosecuted, he would be looking at decades in federal prison. Yes, I said decades. I know I have 35 seconds left, but do you care to comment on that and kind of what you meant by that and maybe your thought processes in delivering that tweet to the marketplace of ideas?
There are so many mandatory minimums and such ease to ratchet up a sentence based on, for example, when you're sentenced for fraud, it's the dollar amount. If it's drugs, it's quantity amount. All of those get you to 20, 30, 40 years in the federal system. And poor inner city defendants that have been prosecuted for the same conduct.
Gentleman's time has expired, but you can continue to finish your answer.
Poor defendants that were prosecuted for the same conduct, they were laughed at if they ever asked DOJ for a diversion.
Thank you, Mr. Chairman. With that, I yield back.
Thank you. Chair recognizes gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chair, and I appreciate your having this hearing. I probably spent as much time on any issue other than Mr. Trump's misconduct over the course of his presidency on the subject of commutations and pardons. In the last and in several Congresses, I've introduced resolutions to limit the pardon power. I know it takes a constitutional amendment to do it, but that's the only way you can do it, really. There's the idea of having a panel is a good idea if the president would abide by it. My joint resolution, which I'd introduce and reintroduce this year, because if it's good for the goose, it's good for the gander. If it's good for Trump, it's good for Biden. It wasn't about Trump. It was about the fact that the system should be fair. Would have not allowed a president to pardon himself or herself, any family member up to a third degree of relation of the president or the spouse thereof, any current or former member of the administration, any person who worked on the president's presidential campaign as a paid employee, any person or entity for an offense that was motivated by directors and significant personal or pecuniary interest of any of the foregoing persons, and any person or entity for an offense that was at the direction of or the coordination with the president. I think we should that bill should come up for a hearing and for a markup. And that's what I think is the appropriate response. What happened in this case, some of the cases with the President Trump, as I understand it, and I only picked this up during the January 6 hearings, Mr. Kushner said that he was not really aware of what was going on in the White House on January 6 or immediately there days before, because he was totally involved in dealing with the pardons. That was Kushner's job at that time, was dealing with pardons. That was shocking to me. Jared Kushner's not a lawyer. His experience with the system is his father had been convicted and was in jail, and I think his father got, through the recommendation of Mr. Kushner, a pardon. I may be wrong on that, but I believe that's correct. Mr. Osler, do you know, did Kushner's father get a pardon?
I believe that I did, and yeah. I'd like to speak briefly to what you're talking about. I think that
sure.
Mr. Kushner knew about clemency and pardons in part because he did talk to experts about it. In August of 2018, I got a message from him asking to attend a meeting at the Roosevelt Room. I asked if Rachel Barco could attend as well, and we sat down for 2 hours and talked about clemency policy and pardons.
And the pardons that he issued were mostly for people with large amounts of money. Now, the president mentioned in his interview with Brett Baer, is it Brett Baer?
Yes.
I don't watch that station, but whatever. He's supposed to be one of the better ones. The pardon of Miss Alice Marie Johnson, and she's a constituent of mine.
Yes.
And she probably did enough time. She'd done 24 years. I mean, it's a long time. But regardless, she was sentenced to life imprisonment. But he said, oh, she was just convicted of something. She's dealing with marijuana. And of course, Brett corrected him. And as I see here, it's about 8 or 9 or 10 different crimes connected, all with cocaine. So the president really wasn't quite aware, even on his most high-profile case that was featured in an ad at the Super Bowl, who he pardoned and for what. Pardon should be available for cocaine too, but you ought to know what you're doing. And then as far as there's a lot of these healthcare fraud cases here that were pardoned, and that seems kind of, these are people making a lot of money. There's a lady here I saw just skimming through the list, Judith Negron, and I don't know Judith Negron. She might be, help candy stripers or, whatever they are, Girl Scouts, and sell cookies and everything else. She is sentenced to 420 months imprisonment and had an $87 million restitution. $87 million in restitution. She must have been a pretty active criminal. And she got a pardon. Conspiracy to commit healthcare fraud. That's a serious thing, healthcare fraud. And that's what this gentleman was doing.
Well, I can say we're both former federal prosecutors, and we know that the way that the amount of loss can be calculated can take in a lot for the person didn't do individually. I believe that Ms. Negron was someone that was vouched for by Alice Marie Johnson. Am I correct about that, Mr. Tolman? And who she had known in prison, and she vouched for her reformation. One thing that we do see, and this was true of some of the grants that President Trump made, was that people who had lower level involvement in major conspiracies were given long terms, and some of them were given relief through clemency.
I've only got 20 seconds to go, and I guess this is conjecture, but I wouldn't be surprised if the amount of money you had and the opportunity for somebody who was issued in charge of the pardon office had an opportunity to get some of that money for their new hedge fund, just like they got $2 billion from the Saudis. And that's wrong to put somebody who'd have a financial incentive to help somebody who's wealthy and got money and you know about it in charge of giving them their freedom. It should be totally detached. And,
This time has expired.
the Caesar's wife and beyond, blah, blah, blah. I
Recognize
yield
the
back
gentleman-
the balance of my time.
There's no time to yield back, brother. I'll recognize the gentleman from Georgia, Mr. Johnson.
Thank you. There's a case out of the Supreme Court of New York that was filed. It's Dunphy versus Rudy Giuliani. And in that case, in that civil case against Rudy Giuliani, it's alleged in the pleadings that Jared Kushner and Rudy Giuliani had a scheme in place to cause folks to pay them $2 million for a pardon or a commutation. And that's just an allegation that is made, no proof, but it's made in a pleading. The lady says, Dunphy says that this is what Giuliani told her. And so this is the kind of, this is what ensues from the kind of process that was in place during the Trump administration insofar as pardons and commutations are concerned. Professor Osler, can you walk us through how past administrations have typically reached pardon and clemency decisions and how that process differed from whatever the process was for Trump?
Yes, and frankly, the process has been, as I described earlier, for the past 5 or 6 administrations, going back to the Reagan administration. So they've all been failed in the same way. And we've seen over and over this mad rush at the end where they realize they want to do something. That brings us things like, what we saw with Mark Rich coming through at the end as well. And this invites all kinds of terrible problems. And probably more than looking at prior administrations, which had the same system, it's smart to look at other states or the state systems where we do see some high functions.
I guess the point I want to make is that it is a good idea to have a system in place like the Obama administration had that it did not deviate from, and there was no mad rush to issue pardons and commutations at the end of, in the final hours of a administration, and the mechanism protected against insiders getting pardoned, like Paul Manafort and Roger Stone. That's the point that I want to make. But as far as this case, Mr. Informers, that we're talking about today, this is a gentleman who was convicted in the largest healthcare fraud scheme ever investigated by the Department of Justice. a federal jury convicted Mr. Informes on 20 of 26 counts and sentenced him to 20 years in prison. And so he was 6 counts hung jury, and those hung jury counts were just hanging out there as he was serving his sentence, whereupon Trump, out of his back pocket with no process, just decided to pardon him. I don't know whether or not it was because somebody paid someone to get that action. I'm not making that allegation, but the fact is he got out. But those charges were still pending. And so hasn't it been your experience that prosecutors have the authority to retry a defendant who has been acquitted on some charges with other charges having arrived at a hung jury and no final disposition on? Don't prosecutors have the power to retry the individual?
Yeah, as Mr. Tolman said earlier, I agree with him that does happen, and that's
Yeah, I mean,
been understanding the law.
that's prosecutorial discretion. The case had not been dead docketed or no prost because the individual had not completed his or her sentence. And talking about Mr. Informes, had not completed his sentence, so those charges that were that the jury hung on were still hanging out there, and then he gets a clemency, gets out of jail, and now the prosecution wants to charge him, wants to try him on those charges. Nothing wrong with that. It happens every day. And by the way, Republicans talk about a two-tier system of justice, but they talk about it in terms of being for white males who've always been privileged, when I find that we have a two-tier system of justice for people of color.
Gentlemen's time has expired. That is some of the most outrageous, I recognize myself for my 5 minutes, which I haven't taken. This is some of the most outrageous, illogical argument I've heard. Let me ask each of you, does it happen all the time, as the gentleman just said, where a president grants a clemency or a commutation, and then the DOJ says, we're going to go back, reinvigorate our prosecution against that person? Does that happen?
I did as much research as I could, and I cannot find a single instance of DOJ re-prosecuting a commutation.
Not a single case. Mr. Ostler, did you find any case? You were of any case?
As I said, I didn't do a systemic check, but I don't know of one. Now, I understood the question to be about hung counts generally where you don't have a commutation.
Right, but that is not what that's not the conclusion he drew, right? And Professor Berman?
Yeah, I was struck because I'm not aware of any case, let alone cases happening all the time, where there's a re-prosecution after a clemency grant.
And let me just tell you, my experience, and it wasn't a federal prosecutor, but I can tell you my experience is, if you got convictions over here, you had a case sitting over here on a hung jury, we typically would just be happy and move on, and that's typically what happened. And in this particular instance, the prosecutors said they were going to move on. Right, Mr.
May I clarify one thing? Yeah. You know, he raises, I don't like the process, I'm not defending the process that occurred under President Trump, but it occurs under every president towards the end, and it is not the right process. But I can say Mr. Informes did not use money or political influence to get his commutation. In fact, he had 2 prior attorneys general, Ed Meese and Michael Mukasey, and Deputy Attorney General Larry Thompson requesting that he receive clemency, largely based on misconduct that DOJ admitted to that was reckless.
Right. I'm glad you brought up the misconduct, which nobody has brought up before. I'm going to ask you some more generic questions and try to get at this. Do you see any limitation in the Constitution right now on a president granting clemency, pardon, or commutation? Professor Berman.
In all Supreme Court cases, and obviously the text it's extraordinarily broad, covering all federal offenses except in cases of impeachment.
Right, that's the way I read it. It's just really broad. I don't know what the limitation is other than impeachment, right? So this notion that somehow it's okie dokie to go back in and basically take this Mr. Informes and say, well, doggone it, we thought he had a really bad set of facts, And so we need to retry him on some of these things to hold him accountable. I'm sorry, appears to me to be biased or motivated from something other than the crime, because they used the hung jury crimes to enhance his sentence. Is that not true, Mr. Ostler?
I believe that the sentence was drawn in part from the hung jury.
Right. So they used those as essentially as enhancers to the sentencing.
Well,
right?
the way that sentencing guidelines work, that there's going to be enhancements that come in.
Right. But not typically hung jury or acquitted cases, right? Mr. Tolman?
Yeah, that's one of the great flaws in the federal system, and I argue is unconstitutional, is that you are allowing judges to sentence on acquitted conduct and even uncharged conduct.
Yeah, that's true. And that's a different issue that we got to get to and fix as well. That's ridiculous.
I'm glad to help on that.
Yeah.
I will say this, that when I teach my first-year law students about the use of acquitted conduct to sentence, they are appalled. It is the one time I see consciences actively being shocked.
And I will just tell you that it's really different from the state cases, too, that I was involved in. You never could use that kind of enhancement for sentencing. That's pretty amazing. So as we get through here, we've got a lot of work on our plate that we have to do, and we're going to keep going forward with that. And so I just want to say, as we close out the hearing, thank you for being here. I think it is a travesty that we're here on this Formers case. It's a travesty that we have a process that seems to be almost unrelentingly broken that has to be fixed. And so I'm certain that my ranking member and I will be happy to work with you all and see if we can come up with some meaningful changes and returns. With that, we're adjourned.
Would you allow me just for a moment?
That was my 5 minutes, and no, we're done. We're adjourned.
Go ahead.
We're done.
Thank you.
I'm sorry, we got this.
Okay, I was just going to interject a point.